Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, and I'm an associate at Samfiru Tumarkin LLP in our British Columbia office. And I'm going to be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law in Canada. Samfiru Tumarkin LLP, as always, is Canada's leading employee-side employment law firm. A couple housekeeping notes. If you want to get a hold of us, please do so, and you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so please send your questions in. We have a few in the queue, but send them all in, and I'll try to get to them all as we go. Okay, question from Terrence. What if your employer puts you back in the conditions you've complained about? Is that considered a form of retaliation? Well, I mean, there are lots of reasons why an employer might. I mean, this is a really broad question. I don't have any specific, Terrence. If you've got anything specific, please send it to me. Specific without identifying you individually, I guess, because you're still at your employer. But, an employer might be, they might have budget constraints. There might be political stuff going on. And what I'm getting at is it might not be solely due to reprisal. However, certainly it could be, depending on the nature of the facts. But retaliation doesn't in and of itself get you there. Now, if you've complained about something that is a human rights protected ground, like you're being sexually harassed, and they deal with it for a little bit and then put you back under the, say, management of the sexual harasser, yeah, you're probably constructively dismissed at that point. That means you've been terminated by the actions of the employer. And certainly you have a human rights complaint as well. But, if you were working on under something that was sort of lesser than that, and then, let's just say schedule. Okay. So you were working Tuesday to Saturday, you didn't like it. They put you to Monday to Friday, you like that. And they put you back to Tuesday to Saturday. Is that a constructive dismissal? No. Right. And just as a refresher for everybody who hasn't been, this is your first time here, for example, constructive dismissal is where the actions of the employer effectively terminate your employment. Okay, so you can pull the trigger on your own termination if you feel that the unilateral actions of the employer have amounted to a breach of the fundamental terms of your employment, or indicate that the employer just really doesn't want to employ you anymore. Apologies for that noise in the background. So you can pull the trigger on it, but you have to be right because zero. Okay, and so the key there is that the actions of the employer have to be fundamental. So or at least the breach of your contract of employment or the terms of your contract of employment have to be fundamental. So schedule change, not going to get you there unless there's an important reason as to why your schedule can't be changed. So something like you have elder care or child care responsibilities, or you have a second job that the employer was aware of that has a set schedule. So it just depends on the degree, right? Wage change certainly could do that if it's over 14%, 15%. At least in BC, I think it varies by province by province. I think Ontario is a little more generous in that regard. So it really just depends. But retaliation in general, even if it is, doesn't necessarily get you to anything that you'd want, right? So, but if your goal, Terrence, is you want to continue working at your employer, you just want to be returned to the other conditions, it's not a lot that you can really do other than having an amicable conversation with your employer, and if your employer will put you back in those conditions voluntarily, that's the preferable result if you want to stay, right? Employment law really deals with money that you get after you leave, or triggering your leaving and getting compensation. So it depends. You got to start with what your goal is, and then work backwards from there. Question from JK. My company is splitting in two. I've been told we're not losing anything. My job, pay, and start date will not change, but I don't know if they're giving us new work agreements. Are they supposed to give us new work agreements? Okay, that's a great question. It's a really good question. So, company splitting in two is odd. I assume that the assets of part of the business are being sold to somebody else. I can't really understand. I don't know why else they would split into two. Maybe if you could shed some more light on it without going into anything confidential or proprietary, of course. If you work for ABC Company and then ABC Company sells off its widget division to DEF Company, nothing changes for you. You still work for ABC Company, right? So your contractual relations don't change. And here's the core of your question. An employment agreement simply takes some of the terms of employment that exist between you and the employer and puts them down on paper that you both sign so that you are both bound by those terms. But here's the thing, 99% of the time, 95, 96, 97, 98, 99% of the time, the employer exploits its superior bargaining power over the employee at the time of contract formation to force the employee to accept terms of employment that are contrary to the employee's best interest. So to simplify that, your contract is for the employer, not for you, the employee. Okay, unless you're a high net worth, or I shouldn't say high net worth, but high demand, high value employee with a higher income bracket. Like a C-suite employee who can dictate some of the terms of his or her contract. But otherwise, employers just saying, "Hey, you want this job? Sign this contract. You don't like this contract? You don't get this job." Or you want to stay employed here, sign this contract. I mean, that would be a little different, but then you'd have legal options. But employers try that all the time. You want to stay employed here, sign this contract. You don't like it, well, we might have to get rid of you. Is generally sort of how that goes, and you effectively have to sign the contract. So if your employer doesn't give you new work agreements, almost always that's in your benefit as an employee. And I'm not going to say always, but and certainly in your specific situation, probably want to get legal advice because I can't, you've got a sort of a half paragraph that you've submitted, and I can't possibly understand, all of your facts and then give you proper advice through this forum. And so I'll say, JK, you should probably talk to an employment lawyer, even if it's just for half an hour. Employmentlawyer.ca, helpinemploymentlawyer.ca, and 1-855-821-5900 if you want to reach us. But 99% of the time, if an employer doesn't give you a contract, good, don't mention it, because it's better for you when the time comes to separate. Because again, the contract's for the employer's benefit to limit its liability. It's not there for you. Because when the employer limits its liability against you, it's limiting your rights. Question from Tad. I quit drinking a year ago, just before starting a new job. Congratulations. At our Christmas party, I didn't drink and was constantly asked about it by coworkers. My manager gave me a drink and told me it was non-alcoholic. This was a lie. Oh. And everyone laughed when I realized. I'm very upset and bothered. If I quit because of this, would I be owed any sort of severance? Well, I think the question is, Tad, were you an alcoholic? And if so, before you quit drinking, and if so, did everyone know at your work, specifically your manager, know that you were an alcoholic? It is monumentally not funny if you were to trick an employee or trick anybody who's a recovering alcoholic by providing them, by telling them it's a non-alcoholic drink and then giving them an alcoholic drink. I think that at minimum, if that's the case, the key is A, are you a recovering alcoholic, and B, did your employer know about it? Okay. And if that's the case, at minimum, you have a human rights complaint. And you it may be a constructive dismissal. I mean, I mean, I guess it isn't, because it's not there's not an ongoing component to this. It was a one-time error, and not tricking you. I'm just trying to think of it. Does it breach a fundamental term of your employment? No. Is the employer sort of indicating it doesn't want to be your employer? No. I don't think it's a constructive dismissal. I do think it's potentially a human rights complaint. I do think it's a problem. I do think if you made an issue of it, through either the Human Rights Tribunal or talking to your boss's boss, I think it would be pretty serious. Again, if you're an alcoholic and everyone knew about it. But it's also the kind of thing, if you like your job, you may not want to make these kind of waves. It's a tough one. It's a tough one in terms of what you want to do, and certainly my sympathy goes to you. I certainly hope that nothing problematic arose for you as a result of consuming this one alcoholic drink. I think that I think you need to think about what it is that you want. Do you want a legal remedy here, or do you just simply want an apology? Do you want to just continue working there and let it go? And then I think you depending on what you decide your desire is, in terms of a remedy, I think that you need then, if it is something that you want to pursue from a legal perspective, like I said, it would probably be just a human rights complaint, and it would be one of on the smaller side. So I'm not sure it's worth it, given, especially if it's a job that you like. But if it is something you want to look into a little bit more, you should talk to an employment lawyer. And again, if you want to talk to us, you can do that at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Thanks, Ted. Appreciate the question. All the best with that. Liz asks, what to do if employer won't reinstate worker after sick leave? Well, it's a complicated question. I mean, it's a one sentence, half sentence question, but unfortunately, there's not enough information to go by in there. I'll just say if employee breaks arm and is out of work for 6 weeks and then says, I'm ready, I've been medically cleared to return to work, and the employer says no, then that's a termination of the employee's employment, because you have a right to be returned to your position. Okay? If they say, well, you have to be able to lift 45 pounds, can you do that? And you say, no, I can lift 35 pounds. Well, that becomes a more complicated question. The employer could say, well, you have a right under most human rights regimes in the country to be returned to your position, and your employer has to make reasonable accommodations for your restrictions. But the employer can argue that being healthy to a significant degree is fundamental to the four quarters of what your job is. So if your job is to lift 45-pound boxes all day and you can't do that, well, is the employer expected to bear that burden? Well, the question becomes, what can it accommodate you? And it gets a little, it's very fact dependent. Generally speaking, you can't lose your job because you were away on a properly papered medical leave. And by properly papered, I mean you got all the correct doctor's notes, et cetera. And then the employer has to accommodate you to the point of undue hardship. Your physical restrictions or whatever they are, to the point of undue hardship. What is that? I don't know. It's generally speaking a high bar, but it's specific to your job. And so, again, going back to my example, if you're a longshoreman and you can't lift things anymore, does your employer still have to accommodate you? And it gets a little bit more complicated. So generally speaking, Liz, they got to put you back. They haven't. You could consider yourself terminated. Why would you want to do that? Potentially consider yourself terminated. You should not do anything like that. And this just goes generally to everybody. If you can make an action which fundamentally changes your employment or ends your employment, don't do that without getting legal advice, because you might make it difficult to, if you do something incorrectly, that it might be impossible for a lawyer to come in and fix it afterwards. So get the legal advice first. If you want to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. As you can see on the screen right there. But Liz, the core of it is they got to put you back, and if they haven't, if they haven't, you may be able to avail yourself of a severance claim, and so that's why you would consider yourself terminated, because upon termination, you can then pursue severance, and how much severance you get. And severance can be quite a bit; it can be as much as 24 months, but it depends on what your employment contract says, and then if you get through that gateway, your age, length of service, and position. Arthur asks, my employer is closing down the plant I work for. I'm sorry to hear that. I've heard a lot of that lately. They've said that I'm classified as a contractor, and if I don't accept a new position at a location 2 hours away, I'm not owed anything. Those are different things. So whether or not you're a contractor is an open question. So that can be debated. So why would they do that? Well, an employee has rights attached to being an employee. Okay. And an independent contractor does not. So employee has employment protections under the Employment Standards Act. If their employment contract with respect to termination does not comply with Section 63 and arguably 64 of the Employment Standards Act, then the termination clause is void, and you get common law severance, which again can be very lucrative up to 24 months. So it's certainly in the employer's interest to say you're a contractor, but it doesn't matter if they say you're a contractor. It's, are you actually in reality a contractor or employee, or a halfway point between them, a dependent contractor who's still entitled to big severance but doesn't get the Employment Standards Act protections that I've mentioned earlier. So, excuse me. So if you're using the employer's tools and you only work for the employer, and you've been working for the employer for 10 years, and you're held out as an employee, and there's a bunch of other factors, you're more likely an employee, especially if you're working in a plant. It's pretty hard to be a contractor if you've been working for years in a plant. Second part. So if you lose your job, the employer says, listen, we're ending your job, but we have this other job that's largely the same, and we're going to pay you the same, and it's half an hour away. Do you have a severance claim? The answer is probably not, because your right to severance, the big severance, common law severance, is not unfettered. It's subject to you making reasonable efforts. Well, I should put it a different way. It's subject to you making reasonable efforts to look for replacement employment. Okay? And any employment or any money that you earn from a new employer is dollar for dollar deducted from what you would have made from the old employer during your severance period. So you're not entitled to double compensation. So any money that you make, so severance runs from the date of termination forward. Let's just say it's 6 months. Okay. Any money you make from a different employment within those 6 months comes off the amount of severance that you were going to get. So if you were going to get $100,000 in severance, but you earned $50,000 from a new job, your severance is worth $50,000. Okay. So you're not entitled to double compensation. Now, if there's a job that you should have taken but didn't right from the start, and it pays you the same, your claim is worth zero. Okay. And so that's what they're doing with the second part. They're saying you have to take this job. Now, you don't have to commute 2 hours for mitigation for that new job to effectively have for the court to say, yeah, you should have accepted that new job. Okay, 2 hours is too long. So you have to decide what you want to do. I don't know if you're in a small town. I mean, I've talked to many people in small towns where the plant is the only place that's going to pay well, or pay what the employee was making. And so maybe a 2 hour commute for that, or maybe even a relocation that halfway between those two towns might be in your best interest over a severance claim. But you have a really complicated situation going on. We don't know if the old employer is still viable, if it still has assets. You can have a great claim severance, but if your employer has no money, it you have a great claim to zero. So Arthur, you have a really complicated situation. You need to talk to an employment lawyer in great detail. I don't know what jurisdiction you're in, but if you feel like it, give us or please feel free to call us if you'd like. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But I'll just say that again, 2 hours is, when you talk about when the law says that you should have accepted a new job and therefore your claim is stopped out right when that new offer comes to you. So in this case, right at the beginning of losing your old job, if it's 2 hours away, that's not reasonable. So 2 hours one way. So 4-hour commute total. No, court's not gonna say that you should have accepted that job. So you got a lot going on, Arthur. Talk to an employment lawyer right away. Oh, hold on. Arthur says there's one more. He's worked there for 14 years. Yeah, so you might have a large severance claim, Arthur. You need to talk to an employment lawyer right away. But again, it's a company. When you evaluate these things, it's not just how much money I'm going to get. It's or potentially going to get. It's what are the priorities of my life, right? And so, a severance claim will get you let's just say you have a full severance claim and you get 12 months of, you have a potential of 12 months of severance, less legal fees and taxes. Okay. That's a nice chunk of change. Okay. But what if you're 50 and you got to get to 65 to retire? Is it a better move for you and your family to just move an hour away? So you're still an hour away from all the people you knew in town A, but now you've got an hour commute to town B for this new job. That actually might be the best thing. I don't know. But you got to think about all these things, right? Because if the plant is paying you 80 grand a year, and if you're not, and you're in a small town, and the new job will pay you 80 grand a year in a different small town, and if you don't take that, you're going to come back in making 40 grand a year in the small town. It might be the best thing to take their offer, right? So you've got to think about what's important in your life, and also what your severance claim potentially is worth, and then make a decision based on all of that. So I hope that assisted, Arthur. But 100%, you need to talk to an employment lawyer. You need to do it immediately. Okay, Paul asks, how long can a company require temporary agency employees to work before they qualify for a position within the actual company? So you're talking about the temp agency, right? Well, I mean, and listen, I don't know very much about this, but there's a contract between the temp employee and the temp agency, right? So the employee works for the temp agency. Then there's a second contract between the temp agency and the company. Okay. So that relationship can continue indefinitely. The problem is that the company is paying both the cost of labor and a premium to the temp agency for the temp worker. So that doesn't make sense for it indefinitely. But also, from my experience in business before I was a lawyer, in order to buy that employee's rights out, for lack of a better term, the employer is going to have to pay, a company will have to pay a penalty to, or an extra percentage to the temp agency, who was the one who found the employee for the company in the first place. Okay, so that penalty cost actually quite often prevents the hiring of the temp agency employee with the company, right? So all I'm saying, there's no legal rights involved in what I was saying there. There's no legal right for you to force the company to make you an offer. It's basically, it's economics, right? You work for the temp agency's charging a premium. How long is the company going to agree to pay the premium for? And I've seen situations where the CEO of a company I've worked for said, well, we don't want to pay this premium. We really like Paul, but we don't want to pay the 30% annual extra penalty fee to get Paul to work for us. Let's just hire somebody else, right? So I talked to the temp agency. I mean, if the company wants you to be an employee, maybe you already know that, and it's just an economics thing. But to answer your question, my understanding, you have no legal right to work for that company. This could go on forever. It's just economically, I doubt it will. This person's unidentified. So I left a job of 3 years for more money and so-called better opportunity with an India-based healthcare company. After several incidents of gender discrimination, I was fired. Should I sue? Is the employer, is it here? Is it in Canada? Does it have assets in Canada? If it's entirely based in India, for example, you can sue them here, but you're not going to get any money. And certainly you're not going to try to have your Canadian judgment enforced in India. That won't happen. So let's start with the first piece. So you left a job of 3 years. So that doesn't matter unless you were induced, right? So they have a New Jersey office, but you're in Canada, presumably. Are you in the US or are you in Canada? So the first part, if you're in Canada, you voluntarily leaving a job of 3 years for greener pastures, or what you thought was greener pastures, that's just, the free market. Okay. That doesn't add any value. So you're in the US. So I'll just say you're in the US. I don't practice law in the US. Your federalism is completely different than Canada's, and your legal rights vary by state, and employee rights are quite a bit different there. So I'm not going to comment on that any further, other than to say I think that you should speak to a New Jersey attorney and in employment law and see if there's anything you can do. But certainly my sympathies to your situation. I don't know if you have a human rights regime there. I know in Canada, you certainly, if you have bona fide gender discrimination, you'd have at minimum a human rights complaint. But with respect to U.S. law, I have no idea. New Jersey law, I have no idea. So I wish you luck with that. And Arthur, you are very welcome. And I think that's it. I think we got to everyone's. She said that she started legal procedures. Well, good luck. I wish you well with that. And again, I don't know. I don't know anything about New Jersey law, and I know some states have, employees are at will employees, in which case they can be terminated without any rights. But in others, I'm not sure that's the case. So certainly, I wish you well with that. And Arthur had some kind words to say as well after we talked about his situation with the plant being 2 hours away. Okay, well, thank you all for your questions. We got through them today. Appreciate all the questions. They were very, very good. As always, if you need to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. This is my last session for the year. It's been a great year. Thank you for such wonderful questions over the last year. I appreciate them all. I will be here doing this in my usual time slot, 10:30 a.m. Pacific time, for the following year, starting sometime in January 2024. So keep an eye out for that. I don't know. Maybe the moderator knows. Are we coming back? There we are. Yes, December 11th, Chris Justice on Monday. Please join us for that. Chris will answer all your questions in employment law. Chris is based in our Ontario office, so different than me. I practice out of our BC office, so law is slightly different in the two locations. A broad similarity in employment law across Canada, but Ontario and BC, there's certainly some distinctions between the two with respect to employment law. So since I'm not going to see any of you to the new year, I wish you a very happy holidays, a safe New Year's, and I look forward to seeing you all next year with your great questions. Thank you.